On behalf of the City of Seattle, Office of Immigrant and Refugee Affairs, welcome to this Citizenship Workshop Legal Training. This webinar is intended for volunteer attorneys who will be conducting the initial screenings of potential citizenship applicants, and also for immigration attorneys who will be serving in other volunteer roles at the workshop and who want to brush up on naturalization red flags. This training will cover some commonly used immigration terms and acronyms, review the legal requirements for naturalization, and look closely at red flag screening issues for naturalization applicants. First, there are a number of immigration terms that you may hear in the context of a citizenship workshop that it would be helpful to be familiar with. There are various federal agencies involved in the immigration system. Within the Department of Homeland Security, or DHS, there are three main agencies that administer the immigration laws: USCIS, or U.S. Citizenship and Immigration Services, processes and grants immigration benefits, including naturalization. Customs and Border Protection, or CBP, is in charge of securing the borders and enforcing immigration law at the borders and ports of entry. And Immigration and Customs Enforcement, or ICE, is the interior enforcement arm of the Immigration Service and handles detention and deportation. The Department of Justice oversees the immigration courts and the Board of Immigration Appeals, both administrative courts. Other departments, such as the Department of Labor and the Department of State, are also involved in different aspects of the immigration system. This slide lists a number of immigration-related terms or acronyms that you might hear at a citizenship workshop. To highlight a few, LPR refers to Lawful Permanent Resident, which is someone who has a green card. Everyone who applies to naturalize must be an LPR. An A number or alien number is the 8 or 9-digit number assigned to a non-citizen by one of the immigration agencies at the time their immigration file is created. GMC is used to refer to good moral character, which is a requirement of naturalization, as well as some other immigration benefits. The N400 is the form number for the naturalization application. Skipping down to the bottom, removal and deportation are used almost interchangeably to mean when a person is expelled from the United States. Removal is the more current term, and deportation is one type of removal. There are several ways to obtain U.S. citizenship. By far the most common is by being born within the borders of the United States or a U.S. territory such as Puerto Rico or Guam. One can also acquire U.S. citizenship at birth if born outside the United States to one or both U.S. citizen parents, as long as certain other requirements are met. Another means to obtain U.S. citizenship is for a child who is a permanent resident to derive citizenship from a parent who naturalizes or is otherwise a U.S. citizen. Finally, lawful permanent residents may become U.S. citizens through the naturalization process, which is the focus of the citizenship workshop. Looking a little more closely at children and citizenship. Although children under 18 years old are not allowed to apply for naturalization, under the current law, known as the Child Citizenship Act, children automatically become citizens when several conditions are met. One or both parents is a U.S. citizen, either through birth or naturalization. The child is a lawful permanent resident, and the child is in the legal and physical custody of the U.S. citizen parent. Because derivation of citizenship occurs by operation of law, sometimes people will be U.S. citizens and not even know it. The Child Citizenship Act is prospective only, in that only people who are under 18 as of its effective date, February 27, 2001, qualify. Prior laws apply to prior time periods. The law of derivation can be complicated because it turns on a person's age, when various requirements were met, and which law was in effect at the time. There are various charts that lay out the law during different time periods, and depending on whether you're analyzing whether someone acquired citizenship at birth or whether they derived it from a parent at some later date. Because someone can be a U.S. citizen under these laws without knowing it, it's important to ask whether someone has a U.S. citizen parent as the first step to determine whether they may already be a U.S. citizen. Now let's turn to the legal requirements for naturalization. This slide shows the basic naturalization requirements. We will go over each of them in more detail, except for the first one, which is that a naturalization applicant needs to be at least 18 years old at the time of filing their application. There are several aspects to the residence requirements. The first part is that a naturalization applicant must have a lawful admission as a permanent resident. Lawful admission requires that the person was eligible for permanent residence at the time that they obtained that status. For example, if they obtained their permanent residence through marriage to a U.S. citizen or a lawful permanent resident, and it later came to light that that was not a valid marriage, that person would not have been lawfully admitted to permanent residence. In addition to lawful admission, an applicant for naturalization must have been a permanent resident for at least 5 years before submitting their citizenship application. Applicants who are married to U.S. citizens can apply after 3 years of residency, as long as they were married to the U.S. citizen spouse for 3 years and are living in marital union with that spouse at the time of filing their naturalization application. In counting when residence begins, there is a special rule for asylees and refugees. For asylees, their residence starts 1 year prior to the date that their adjustment to permanent residence was approved. For refugees, their permanent residence date goes back to the date of their admission as a refugee. This date should be reflected on the green card, but you may want to check that this rollback rule was accounted for. This is an example of the current version of the green card, also known as the Lawful Permanent Resident Card, or the I-551. The green card is an individual's proof of status as an LPR. As you can see, the resident since date is printed on the bottom of the card, and the category the person was admitted in is in the middle of the card. In this case, the category was RE8, which is a refugee category. The A number is the 9-digit number printed on the middle of the card. Here it is labeled USCIS number. Although I-551s need to be renewed every 10 years, LPR status itself does not expire. Returning to the residence requirements for citizenship. The 5 years of residence must be continuous. In other words, during the last 5 years, certain long absences from the United States may break the continuity of residence. Usually, trips outside of the U.S. for 6 months or less don't affect continuous residency. Trips between 6 months and a year may break residence. It's a question of showing ties to the United States while out of the country. These ties include things like keeping a home in the U.S., family remaining in the United States, returning to a job, maintaining bank accounts, and so forth, while away on a trip. USCIS presumes that a trip between 6 months and a year has disrupted residency, but the applicant may rebut this presumption by providing objective evidence of ties to the United States. Trips 1 year or longer automatically break continuous residence. An LPR will have to accrue at least 4 years and 1 day of residence after returning from a trip a year or longer in order to be eligible for naturalization. Another issue to consider when looking at an LPR's time outside the United States is abandonment of residency. This is not a naturalization eligibility issue, but it can make the person deportable. In deciding this, an immigration judge will consider whether, during a long trip, the person intended to abandon their residency, or if they always intended to return to the United States after a specific event. There are a few other parts to the residency requirement. A naturalization applicant must live in the USCIS service district where they file the N-400 for at least 3 months before filing. They must maintain continuous residency in the United States from filing until oath ceremony, which currently is a time period of about 8 months to a year. They can still take short trips out of the United States during this time, but none so long as to break continuity of residence. An applicant can file their N-400 application as many as 90 days before they complete their 5 years of residency. In other words, they can file 4 years and 9 months after receiving permanent residence. If filing under the 3-year rule, they can file after 2 years and 9 months of lawful permanent residence. Another naturalization requirement is physical presence. A citizenship applicant must be physically present within the borders of the United States for half of the statutory period. This equals 30 months for general applicants or 18 months for those applying under the 3-year rule. Even if an applicant doesn't have long trips, but instead many short trips outside the country, you may need to count up the days of travel to ensure they met the physical presence requirement. Note that any part of a day spent inside the United States counts as a full day for meeting physical presence. Next, let's look at the English requirement. Citizenship requires basic English skills, not perfect English. Applicants will be tested on their speaking, reading, and writing skills at the naturalization interview. If someone can hold a basic conversation about their application with you in English, they are probably able to meet the English requirement. The immigration officer will test their spoken English by interviewing them about their citizenship application. If someone doesn't qualify for an English exemption and they cannot talk to you in basic English, they are probably not ready. Reading and writing skills will be tested at the interview by giving applicants 1 or 2 sentences to read and write from a preset list of vocabulary, usually having to do with civics topics. As a screener, you will conduct basic screening of participants' English skills. If their spoken skills are shaky, we can inform them of the requirement and let them decide if they will be able to study and learn sufficient English during the 8-month or so time period that their application is processing. If someone is illiterate in English, we will not go forward with their application and instead refer them to ESL, as it may take longer than processing times to acquire basic literacy. We encourage everyone who is not ready to take ESL classes and study more, but we leave the decision up to each person as to whether they want to move forward. Some older participants at Citizenship Day may qualify for an exemption to the English requirement. These exemptions are based on age and the length of time someone has been a lawful permanent resident. If an applicant is over 50 years old and has been an LPR for at least 20 years, they don't have to meet the speaking, reading, and writing requirements. They must still pass the history test, but they can take it in their native language with an interpreter. Similarly, if someone is over 55 years old and has been an LPR for at least 15 years, they qualify for the exemption. Both age and residency length must be met at the time of filing the citizenship application to qualify. There is a separate waiver process for applicants who are unable to learn English because of a medical diagnosis or disability. This requires a doctor to make this determination and to sign a form, and so we do not handle this type of case at the citizenship workshop. Another requirement is basic knowledge of U.S. history and civics. Applicants will be given a test on U.S. history and civics at the naturalization interview. The officer will ask them 10 questions from a list of 100 questions that they have been given to study. If they answer 6 questions correctly, they pass the test. So applicants who are over 65 years old and have been residents for at least 20 years can study a shorter list of questions. Since this group of applicants would also qualify for an English exemption under the 50-20 rule just mentioned, they can take the test and interview in their own language. As mentioned previously, applicants with certain medical diagnoses may be able to request a waiver of the English and history requirements. This is known as the disability waiver and requires a Form N648. A medical doctor, doctor of osteopathy, or clinical psychologist must make this determination and state that the diagnosis or condition prevents the person from learning or remembering information. The doctor must provide a substantial amount of information about the condition on the N648 form. These waivers are not easily granted. Because of these complications, we do not handle this type of case at Citizenship Day, but will refer any applicants with this issue to a community partner for assistance. Citizenship workshops are designed for eligible lawful permanent residents with uncomplicated cases who can go through the remainder of the process without legal representation. The naturalization process is the final opportunity for the Immigration Service to review an individual's immigration file for any problems. Serious issues raised on an application can result in more than just disappointment and the loss of the $725 application fee. In some cases, a person can lose their permanent residency and even be deported. Because so much rides on the naturalization process, we need all of our volunteers to be meticulous in asking all necessary questions. The final requirement for naturalization is the good moral character requirement. This is the most complex requirement and the one that most people run into trouble with. Many good moral character issues overlap with removal issues. The law does not define what good moral character is, but it does list types of conduct that prevent someone from showing good moral character. These are listed at INA Section 101F. These are many of the issues you will be screening for at the screening station, and we will go over them in greater detail. We think about screening for good moral character as a three-step process. First, is the person barred from establishing good moral character under one of the mandatory bars? This means they will have to wait until the disqualifying act or behavior moves out of the 5-year statutory period. Second, could the person be denied under one of the discretionary grounds? This means they can either try to overcome the disqualifying factor or wait until it is out of the statutory period. And finally, do any of the good moral character issues or anything else in the person's immigration history make them potentially removable from the United States? To be eligible for naturalization, an applicant must show that they have been a person of good moral character for the 5 years prior to submitting their citizenship application. As with the residency requirement, this period is shortened to 3 years if married to a U.S. citizen. The statute lists a number of types of conduct that, if occurring within the last 5 years, mean that a person can't show good moral character. We refer to these as mandatory but temporary bars. For example, if someone practiced polygamy during the last 5 years, they would be barred from showing good moral character until the conduct occurred more than 5 years ago. The law also contains discretionary bars. These may prevent the person from showing good moral character unless they can show extenuating circumstances. For example, if someone didn't pay required child support that they owed during the last 5 years, they would be barred unless they could provide an explanation for why they were unable to do so. In making this discretionary decision, an immigration officer is supposed to use the standard of the average citizen in the community. Remember, perfect moral character is not required. This chart lists the kinds of conduct that prevent people from showing good moral character if they occurred during the statutory period. Note, however, that there are a couple of permanent bars, things that prevent people from ever showing good moral character. These include a conviction for murder at any time, or a conviction for an aggravated felony after November 29, 1990. Aggravated felony is a category of crimes under immigration law, which includes a wide range of offenses, from thefts with a year sentence, to sexual offenses, to drug crimes, crimes of violence, and many more. The remainder of the list on the left-hand side are bars that are mandatory if they occurred within the last 5 years. They are temporary in that once they are more than 5 years old, the person is again eligible to show good moral character. The list on the right contains acts that may cause immigration to deny because of lack of good moral character, unless the person can show extenuating circumstances. For example, a person may owe back taxes, but is on a payment plan to the IRS, or they have a reckless driving conviction, but can provide a reasonable explanation for what happened. Often, it is helpful to submit evidence showing community involvement or other positive equities for an officer to consider in the balancing test. Now, we'll turn to the red flags screening process at the naturalization workshop. This is the general flow of a citizenship workshop. You will have been sent several short videos explaining process and logistics of the workshop. Each participant will have at least 2 immigration attorneys reviewing their case during the workshop to help ensure success in their application. The screening station is the first stop after intake. This is where volunteer attorneys screen participants for red flags and other eligibility factors such as English language skills. Experienced immigration attorneys review each case and decide if the person should be referred out or can go forward. Participants will either proceed to the form station to complete the N-400, go to referral experts because they shouldn't apply now or because they need to obtain other documents to determine eligibility, or see an experienced immigration attorney for a consult because they have a serious red flag. All pro bono attorneys at the screening station are covered by the liability insurance of one of our nonprofit partners. Let's look at the steps for the red flag screening process. When you first meet a participant, introduce yourself. Ask for the tracking form, which the participant received at intake. This form will be your guide, listing all the steps to take with each participant. First, review the limited legal services agreement with them. The agreement covers issues such as confidentiality and the importance of being truthful, given the potential consequences of denial or deportation. Screeners are to keep the agreement after signing it with the participant. Next, go through the eligibility screening as outlined on the tracking form, which includes looking at the person's green card, checking their age, and checking how long they've been a permanent resident. Determine if they are eligible for an exemption to the English language requirement based on age or residency under the 50-20 or 55-15 rules. Then proceed to the red flag screening form, which begins with questions related to English ability. Screeners will use the English literacy test cards to evaluate English skills. A few misspellings or mispronunciations are usually not a problem for passing the test. Individuals with shaky English skills should be referred to ESL classes, but they can choose if they wish to continue in the workshop. Individuals with no English literacy skills should be encouraged to wait to apply for citizenship until they have acquired basic literacy or until they qualify for an English language exemption. Next, go over the entire red flag screening form, also called the red flags checklist, with the individual. After you are finished, review any yes answers with one of the immigration attorneys, the screening experts, who will be in the room. Both the screener and the screening expert should remember to sign the tracking form. The red flag screening form is the 2-page checklist we use to screen for potential problems that could result in denial or removal. Go over every question with the applicant, asking it in multiple ways if necessary. Follow along now as we go over the questions. In the first 3 questions on the red flags form, you will assess whether the person can meet the English and history requirements. You will already have determined on the tracking form if they qualify for an exemption to the English requirement. If not, go on to test literacy using the literacy test card at your station. If they make a few mistakes, you can recommend ESL classes through a referral expert. If their English skills are very poor, explain the English requirement and recommend classes before they apply. Or they could wait until they qualify for an exemption. If they are insistent about moving ahead in spite of poor English, document what you advised about the necessity of English classes. Our preference is that if a person is illiterate, then they should wait to apply and be referred out of the workshop. In question 2, ask whether they think they can learn the 100 history questions and give a few examples if necessary. If they have very poor or no English, or think that they could not learn the history questions, ask question 3, which concerns the disability waiver. This is for individuals who have a medical condition such as dementia, stroke, or PTSD, which prevents them from learning or remembering information. If they have such a medical condition, or state that they have memory problems, they may be eligible for a waiver and should be referred out. Question 4 relates to whether the person may already be a U.S. citizen. As discussed earlier, having a U.S. citizen parent may mean that a person derived citizenship from that parent. If so, ask when the parent became a U.S. citizen and how old the applicant was at the time. The screening experts will do further questioning if the person was under 18 when their parent was or became a U.S. citizen. Remember the current law. If the person was admitted as an LPR, under 18, and in the legal and physical custody of a U.S. citizen parent, they may already be a U.S. citizen. This law applies to them if they were under 18 as of February 27, 2001. Question 5 asks how a person got their permanent residence. We ask this question to make sure they had a lawful admission to the United States when they got their green card. On the front of the green card is a code indicating in what category they entered as an LPR. We want to feel assured that admission in this category was lawful. As a screener, your job is to ask about how they got their permanent resident status, such as through a family member, through work, or as a refugee. Check the code on their green card and write that down. We will have a list of admission codes in the screening room to check what category the code represents. The screening expert who signs off on your red flags checklist may ask additional questions of the participant to confirm that this admission was proper. Question 6 asks about long trips outside the United States and relates to the requirements of residency and physical presence. Although in screening we ask about any trips since getting their green card, the N400 only asks about trips in the last 5 years. We ask about any trips because we want to screen for abandonment issues as well as continuous residence. You should write down any trips over 6 months, even if outside the last 5 years. If they have long trips, you can ask follow-up questions about reason for the trip or ties maintained to the United States while gone. Many applicants will come prepared with an N400 worksheet that lists all their trips. Remember, if a person has a trip 1 year or longer within the last 5 years, they will have to wait until at least 4 years and 1 day after they return from this trip. Trips over 6 months within the statutory period require the follow-up questions and likely will result in referral out for representation. Question 7 relates to physical presence in the United States and asks if the person has been outside the U.S. for more than 2.5 years during the last 5 years. If it appears the person is close to that time period, you may need to count the days that they were gone. An applicant needs at least 912 days, or 30 months, of physical presence during the last 5 years to meet the requirement. Applicants under the 3-year rule need 18 months. Questions 8 and 9 ask about failure to file tax returns or to pay taxes, both of which are discretionary bars to showing good moral character. An applicant who owes back taxes can still show good moral character if they show that they have a payment plan in place with the IRS and are making payments. Also, not filing taxes may not be a problem if the person can show they were not working or were not earning enough to file taxes. Be sure to write down the years that a person did not pay or file taxes and the reasons why if a person answers yes to either of these questions. Question 10 asks about selective service registration, which is a common good moral character issue. The rule is that all males between the ages of 18 and 26, except for non-immigrants, are required to register for the selective service. Even undocumented males are supposed to register. The only exception is non-immigrants. Not registering is a good moral character problem when the person willfully fails to register. In many cases where the person did not register, it was because they were not aware of the requirement, which means their failure to register was not willful. At the workshop, they can write an addendum to the N400 with a brief statement to this effect. If the applicant is unsure whether or not they're registered, check their registration at the Selective Service website. If the client is 25 years or younger, they can register online. If the client is between 26 and 31 years old and failed to register, this is still a discretionary bar to good moral character. If the failure to register was not willful, they can submit the addendum explaining this. In addition, they need to get what's called a status information letter from the Selective Service. If the client is over 31 years old, the failure to register is outside the statutory period and can't be used to deny their application. Even so, they should still submit the addendum explaining why they did not register. Question 11 asks about false claims to U.S. citizenship and unlawful voting. Someone may have made a false claim to citizenship at a port of entry, on an I-9 form, or when registering to vote, to name a few examples. Each of the issues asked about in this question, making a false claim to U.S. citizenship, registering to vote, or unlawful voting, are all discretionary bars to showing good moral character. This means that if the person can provide a reasonable explanation, such as that it was a good faith mistake, it may be possible to overcome this bar. There is also an exception for those applicants who had U.S. citizen parents, were LPRs before age 16, and who reasonably believed that they were U.S. citizens at the time that they made the false claim to citizenship or voted. If a person is registered to vote, they will need to deregister with the county election board and obtain their voting history, if any, as first steps to resolving the issue. Although this bar to good moral character can sometimes be overcome, it is important to note that both unlawful voting and making false claims to U.S. citizenship are deportable acts. Because applicants with this red flag will need to submit additional evidence if they proceed at all, they will be referred out for legal representation. Question 12 asks about whether a person has applied for citizenship before. The reason they were denied can be important to determining whether they will be successful this time. If a prior application was denied because of a reason that has been corrected, for example, they now know sufficient English or they have enough years of residence, then we can assist them at the workshop. If the application was denied for another reason, such as a good moral character issue or questions about their LPR status, we'll likely need more records and will have to refer them out for legal representation. In any case, if they answer yes to this question, ask when and why any prior application was denied. As a screener, you only need to ask question 13 if you determine in question 5 that the person obtained LPR status as an asylee. Asylees who travel back to their country from which they sought asylum may raise questions about the validity of the original asylum grant. Even though recent case law confirms that adjustment to permanent resident status terminates asylee status, we still want to be careful that there are not problems related to the validity of an applicant's status. Because of this, in most cases, we will refer these applicants out for individual assistance. Question 14 asks about polygamy, which is a bar to good moral character. Polygamy is the practice and ideology of having more than one spouse. If a person came to the United States to practice polygamy during the last 5 years, it is a mandatory bar to showing good moral character. In addition, if their LPR status or ability to apply for naturalization after 3 years hinges on their marriage, anything that calls that marriage into question is a concern. Questions 15 and 20 relate to providing false information to government officials. This could be a government agency that administers public benefits, or an immigration agency providing immigration benefits, such as a visa or entry to the United States. If a person gave false information, such as misrepresenting their income, to a state agency administering public assistance, this could be a discretionary bar to good moral character. Giving false testimony to get an immigration benefit is a mandatory bar to good moral character. This type of false testimony must have been given orally, under oath, and does not necessarily need to be material to being eligible for the benefit. For example, if someone gave false information regarding their travel history at a citizenship interview 3 years ago, they would be unable to show good moral character until that misrepresentation was more than 5 years ago. Giving false information to an immigration official can also result in loss of LPR status. For example, if someone gave false information to get a green card, such as by entering into a fraudulent marriage, this could result in loss of status. Or if someone received an immigrant visa in a family visa category that required them to be an unmarried son or daughter, but they were actually married when they immigrated, this false information could result in loss of status and removal. Question 14 asks about alimony and child support. Willfully failing to support one's dependents is a discretionary bar to showing good moral character. If someone failed to support their dependents, but it was not willful, because they couldn't contact them or because they were unemployed, for example, they could potentially overcome this bar to good moral character. If an applicant has minor children overseas, you will want to ask about how they are supporting those children. Question 17 relates to alien smuggling, a term which is broadly defined by immigration to include many types of aiding, assisting, or abetting someone to enter the United States without inspection. This includes not just acting as a coyote or smuggler, but things such as sending money to pay for a smuggler or walking across the border with someone who doesn't have papers. Any act deemed alien smuggling is a mandatory bar to good moral character if it occurred during the statutory period. It is also a ground of deportation, even if there was not a conviction, if it happened at the time of someone's entry, before entry, or within 5 years of an entry. If someone was convicted of alien smuggling, it would be a permanent bar to showing good moral character if it occurred after November 29, 1990. If this red flag comes up in any case, they will be referred to complex cases for advice and then for legal representation. Question 18. Someone who has imported themselves by illegal gambling or has 2 or more gambling offenses is barred from showing good moral character. This is an uncommon red flag, but may also come up when asking about arrests or criminal charges. This bar doesn't require a conviction and may be based on something someone admits during the interview. Question 19 asks about problems with alcohol or drugs. You could break this question into 2 parts. Let's look at alcohol problems first. The statute bars anyone who is a habitual drunkard from showing good moral character. There's no clear definition of habitual drunkard, but likely it is similar to a chronic alcoholic. Because of this lack of clarity, any indications of alcohol problems should be flagged. Alcohol abuse can raise other good moral character issues. For example, 2 or more offenses with combined sentences imposed of 5 years or more is a bar to good moral character. This could be triggered by some alcohol-related crimes that on their own might not be bars to good moral character. Also, if someone has been confined to a penal institution for 180 days or more during the statutory period, this is a bar to showing good moral character. This applies to any offense, not just something like a DUI. In addition, a person is unable to naturalize while they're still on probation or parole. This is relevant to DUIs and other alcohol-related offenses, which often carry a term of probation or parole. Even if DUIs or other alcohol-related offenses aren't a mandatory bar to good moral character, they can be a negative factor in the discretionary determination about good moral character. Drug usage and convictions can cause serious problems for non-citizens. Before asking about drug problems, screeners will want to read a warning statement about marijuana use, which will be provided at the workshop. Having been convicted of or admitted to a controlled substance offense is a bar to showing good moral character and a ground of removal. Even though marijuana for personal use is legal under state law, possession is still a federal crime, and as such can have increased risks for non-citizens. Being a drug user or addict is a removal issue and may be triggered simply by something an applicant admits. As such, it is very important that applicants do not discuss any drug use with immigration officers without first talking to an immigration attorney. In addition, if an immigration officer has reason to believe that someone is a drug trafficker, based on information in a police report, for example, that is also a bar to showing good moral character. In questions 21 and 22, we want to identify any incidents of immigration enforcement against a person, including past detentions, stops, or deportation proceedings. We ask about these prior contacts because they could raise questions about inadmissibility, either before or after the person got their green card, which in turn could raise questions about their status. If a person answers yes to any of these questions, get as many details about the incident, including when and where it happened. The participants will most likely be referred to a complex case attorney and then referred out for legal representation. Question 23 asks about domestic violence history and is a red flag when the person has been the perpetrator of the domestic violence. A finding that a person violated a no-contact order or a domestic violence protection order is a potential removal issue. Also, a conviction for a crime of domestic violence is a ground of deportation. Any participant with a history of domestic violence as the perpetrator will be referred to a complex case attorney for additional advice. Questions 24 through 27 ask about a person's criminal history, if any. We ask lots of detailed questions about a person's interactions with the criminal justice system, including about arrests, fines, charges in court, convictions, jail time, and so forth. Be sure to take your time asking these questions and writing down details of the incident. Applicants need to disclose all interactions with the criminal justice system on the N-400. USCIS generally requests court records for all criminal matters. Many crimes can bar good moral character, and some are also grounds of removal. For this reason, anyone with a criminal history will be referred to the complex case attorneys for additional advice. If someone has only traffic violations, they can continue through the workshop as long as they understand that all fines should be paid off before their interview. The final question on the red flags checklist asks about any associations with terrorism, communism, or gangs. Any of these involvements can bar someone from naturalizing. For example, if a person has any voluntary involvement in communist activities, they cannot naturalize until 10 years after their last involvement. The exception is if someone's involvement in the Communist Party was required by law, in that they had to participate in order to obtain food, work, or other necessities of life. In that case, participants can write an addendum about their experience and proceed through the naturalization workshop. Any other yes answers to this question should be flagged for further review by a complex case attorney. This concludes our review of the red flag screening form. We hope it has been helpful in familiarizing you with the screening issues you'll be working with at the workshop. You will receive a brief refresher training morning of the workshop before the participants arrive. Also, be on the lookout for other training videos that deal with logistics and flow of the workshop. Thank you for your willingness to volunteer and to help Seattle be a more welcoming city. If you have questions, feel free to contact us at the emails listed on the final slide.